welcome to the Digital India Dialogue series which this group has started. This is the second of the series. The first was done online webinar on the 23rd of August at on the CII platform, which, as you know, CII is one of India's largest chamber of commerce. So that was on the 23rd of August. This is the second event of the series, and it is a physical event, as you can see, at the India International Center. The data protection has been in the works since the Kutswami judgment on 24th of August 2017, nearly 6 years back, where a unanimous judgment of 9-0 and the Supreme Court laid down the fact that data privacy is a fundamental right of an individual. Hence, the DPDP Bill 2023 was the fifth iteration in 6 years of hard work, and now the bill has seen the light of the day a few days back, and we are on our digital journey of legislation, and there are many more things to come. And in the harbingers of things will be the India Digital Act, which will follow. So this is really the first marker of running a digitized society in a legalistic and a formalistic manner. So as you know, the Indian digital footprint is very, very large, and some of the numbers are absolutely mind-boggling. And in some cases, we are decidedly the largest digital community in the world. For example, there are 83 crores, 830 million connected citizens in India, the largest connected community in the world without any exceptions. It doesn't mean everybody is all the time being worked digitally, but they're digitally connected. There are 53.58 crores WhatsApp users, which is 535 million WhatsApp users in India, which is larger than the population of many European countries. And as India moves into the digital economy, the sheer size of the digital footprint really mind-boggles us and also gives us the responsibility to act properly in a legislative way and in a formal way as we move forward. There are 135 crores plus Aadhaar cards, which is like kind of an identity card for aliens, That's 1.35 billion. And there are 90,000 e-commerce sites, small and big, both B2B and B2C. There are 43,000 plus hospitals and about 1.18 million beds, which means all the healthcare digital records, which are private records, is also a big challenge. There are 34 large banks in India, and there are 225 crore accounts in India, bank accounts. So you can imagine the large amount of, in terms of the UPI transactions, in the month of May, there were 9.41 billion transactions, transacting 14.3 trillion rupees in 1 month. So you can imagine the size of how the Indian population is using the digital interface. There are 369 million Facebook accounts, and and you can go on and on with this thing. But the whole idea is to give an idea that the fabric in which we work is a very large and complex fabric. India is also a multilingual society, so therefore there are 16 official languages and many dialects. So also technologies like artificial intelligence will convert what we say in English into various languages so that it's better understood amongst the rural population and in the smaller towns. So DPDP Act is a very, very important act, and it embraces this entire large digital crowd, and we have to make sure that we are legalizing it properly, we are using it properly, and we are creating an ecosystem properly which has been framed by the DPDP Act already. So there's the data principle, there's the data fiduciary, there's a data processor, there's a consent manager, and finally, of course, the data board. So I'd like to stop over here and request our chief guest. We are very lucky to have Justice V.N. Sinha, who, despite his huge preoccupation, has consented to come and spend some time with us. And I would like to request Justice Sinha to say a few words as an opening remarks before I open the roundtable. Over to you, sir.
Thank you. Mr. Dey and other participants, including those who are hearing us virtually. It is my privilege to be part of this program. to understand the implications of the Digital Personal Data Protection Act 2023, which has not yet been enacted because it has only been passed by the Lok Sabha for the present, and the bill is pending in the Rajya Sabha. The need, as Mr. Dey rightly informed us, that in 2017, Supreme Court reiterated its earlier judgment that 92090 Constitutional Bench judgment came only to clarify a judgment of 1963, where the Supreme Court had already held that privacy in all forms, not only digital privacy, but privacy, every private affair of an individual is a fundamental right, and nobody has the question such rights. But this takeover by the technology has exposed us completely. And this exposition of the human individual personality has persuaded the parliament to come up with this enactment. And this enactment is not the first enactment which is coming. They have made several attempts because it is very difficult to correlate and to ensure that both some problem there.
You switch off the mic.
Yeah, sorry, sir.
I'm sorry there was some glitch here, but now I suppose it is over. So I'll carry on. This enactment is only an effort by the parliament to ensure that the data protection and the right of the persons who want to use that data for lawful purposes is regulated. And for regulating the data processing, this enactment has come into being by providing for a principal data person and the fiduciary person who will preserve the data, and there will be a data processor. So to regulate the rights of the three, this enactment has come. And for that purpose, they have provided for the Data Protection Board, and the consent is required to be taken from the data principal by the fiduciary or whoever is to use the data for its processing and further use of the corporate and others for lawful purpose. So this is the very object of the act. It is a very small piece of enactment, but providing for very substantial and effect, which will affect the entire compass of our relationship between those whose consent we have taken, for processing their data, and also to ensure that data which has been collected before coming into force of this act. So how to deal with those data? For them, it has been provided that within a reasonable time, the data fiduciary will obtain the consent of the principal and then proceed to process for lawful use. Lawful use has not been defined, but anything which is not prohibited in law is lawful, and that is how a open-ended thing has been made for using the data for the purposes of business and services. So these are the things which, as an opening remark, I would like to say, and allow the other participants.
Thank you so much, Justice Sinha. Thank you so much for your valuable comments. I think as is well known that big companies use digital personal data of everybody to run their business. And the question is, do they use it only for running their business specific to the service they provide us, or do they use the data for other purposes? And if so, then how does the data principle, that is you and me, get violated by that? So that is really the purpose of this law, to balance it between the data principle and the data fiduciary, who are actually using the data for running their own businesses. And so the first principle is the method of collection of the data. So India has been collecting data in a very systematic manner, whether it's a hospital or a bank or a simple Aadhaar card provider, etc. So the method of collecting of the data minimalization. That suppose if I require, let's say I'm an employer and I'm hiring an employer, I require only 5 parameters of the data. I should only take 5. I should not ask for the 6th and the 7th and the 8th. So the minimalization of the data. So this act provides the method of collection and minimalization of the data and the purpose for which it is the data is required. And the data should be limited to that purpose only by the aggregator, by the fiduciary, and by the big company, etc. And finally, the obligations which come therefrom. So it took 6 years to bring this into law, and I think my personal opinion is I think the government of India and the legal experts who framed this has done an excellent job. They went through the European laws, they went through the laws in Philippines, they went through the Singapore laws, and I would say ours is kind of close to what the Singapore laws are. So, and the purpose of this bill is not restrictive. The bill has a couple of characteristics. One of that, it is an evolvable bill because technology will change and technology will change at a rapid pace. And so the bill has to adjust itself according to the technology. This is the first time a legislation is like a balloon. So it has to emerge out of a technological environment which is constantly evolving and changing. So that is another thing we need to remember. So this particular bill is really for businesses to do well, for the entire ecosystem to do well. It is not a restrictive bill. And with that, I'd like to request Prerna, our so to come and tell us about your deliberations and the origins of this thing.
Thank you so much, Justice V.N. Sinha and my colleagues today for setting the context right for the discussion we are having today. So in today's session, we're going to take a quick dive into the PPDP Act, its applicability, what can companies, what data is it applicable to, the rights and obligations of all the stakeholders, the principal, the fiduciaries, and the data protection board, and the data protection exemptions under it. What kind of industry is exempted from it? The government has, wide powers to exempt itself from it. So that is a loophole in that. And the most important will be the penalties under it, which are quite strict. So before the DPDP came into force, we did not have a standalone act for data protection in the country. So it all came with, right, as actually said by both of you, it all came with the Supreme Court judgment 2017, Justice V.K. Swamy versus Union of India. That was basically arising out of the Aadhaar card, but yes, it set the context right. The data privacy is important. Everyone has the right to protect his individuality on whatever form it may be. So, in that, an important part was also the right to be forgotten, which is not exactly covered in this act, but that is also a very important point for discussion and deliberation. So, then after that, the need for the act came. 6 years after this, the act came into being. So data processing is important because it can subject to individuals to financial loss of reputation and profit. So a lot of stakes are there. So that is why it is very important. Earlier to that, only IT Act of 2000 were governed this thing. Section 43A of the IT Act, read with the SPDI rules, provided for the compensation for mishandling sensitive personal data. And finally, now after this act has come into place and it will be effective, this for 43A Act and the SPDI rules would be redundant. So now, coming to the implementation part, it is not yet clear when it is exactly to be implemented. The government is not given any timeline with regard. Rules are yet to be framed. So we are waiting for the rules to come in and to give it an official notification. So the stakeholders are divided on when the sun will set on the existing law and when this new law will come into effect. So the sunset period, the implementation period, nobody is clear about. So this has, in a way, given corporates a good time to transform itself and to accustom with the act and to make necessary changes to face this challenges. So the government is engaging with the stakeholders to arrive at a time period that companies will get to implement the new DPDP. The industry is betting on a 2-year time frame to implement the new privacy law, just as the European Union had granted the industry before the GDPR came into force. So GDPR, this act is also broadly in line with the GDPR only. So with 44 provisions and a schedule on penalties, DPDP Act as such does not have a sunrise provision and may likely to be implemented in a phased manner. The government may implement it in a phased manner by notifying various sections that will come into force gradually. So it will most probably take effect periodically. It will be interesting to see this effect. Furthermore, the industry have raised the rules, and as the devil is expected to be in the details. The details, until the details are out, we cannot really infer what it is to be done by the corporates, what forms are required, what things are to be in place, and of course the constitution of the board and the eligibility criteria and everything else. So the rules are to be implemented, and so companies have time to transition to a new format. Another law that DPDP will affect is the RTI Act. So that is also another point of debate. The provisions of the DPDP Act dilutes the RTI and thus may severely restrict the scope of the RTI regarding access of information. This is altogether a different topic. So with this, I've laid down the context, we've given you all the introduction. Now we can ask Neil to.
So Neil, can you please tell us the risks, the investments, and ESG implications of the DPDP Act, please?
Yeah, absolutely. So I will be giving an overview from a governance risk compliance related perspective, like the more technical breakdown of what the act actually means for businesses and how businesses can actually get affaired. Like a previous speaker has said, the act has only been passed by the House of Parliament, but businesses have time for compliance until and unless the provisions of the rules start getting implemented. The first thing to note is who is this law applicable to. So the act defines everything as a very sensitive data, as very personal data, as very broad. So personal data is being defined very broadly, and it is not categorized into extremely sensitive or less sensitive. It's just a broad category of personal data. It applies to data collected in a digitalized format or any data which is collected offline and then later digitalized. The type of data over here is irrelevant. Anything that identifies a person, it could be name, it could be age, it could be height, it could be email, anything that is captured online or captured offline and then made online will come under the regulatory ambit of the DP, the Data Protection Bill. Sorry. The Data Protection Act has extraterritorial jurisdiction. I will get to that later. So, it can be applicable also outside India if, there is provision of services, goods and services to people which is located, to anyone located in India. So, if you're sitting outside India and you're providing goods and services to somebody inside India and there is data transfer, then it will also be applicable. I will get to that a little later. What also is noticeable over here is that the bill divides into three categories. One is a data fiduciary, a data principal, and a data processor. A company will very neatly fit into the category more of the data fiduciary and the data processor. The definitions are an improvised version of the European Union GDPR 2016-679. That is the mothership which is the definitions have been taken from. But the definitions are also slightly changed, just the nomenclature. Where the data fiduciary is the person who holds the data, and the data processor is the one who processes the data. The fiduciary will have a lot of long range of obligation, which I will now get to. And the processor, if the processing is outsourced, that the data fiduciary does not have the processing and the processing is outsourced, then liability will also be attached to the data processor. The bill, unlike the European Union regulation, does not restrict passing over of liability events. So if the data fiduciary has outsourced the data processing to a third party, you can pass on the full liability to the data processor. It doesn't have to be that the data fiduciary will take the full liability as long as the agreement. There has to be a contractual agreement, and that agreement has to pass on liability in no uncertain terms. The issue with the data principal, the person who has been collected from the individual whose data is being collected has a set of rights, and these are constitutional rights now because and will have to be enforced, which are you can find that in Schedule of Chapter 3 of the DP Act. But the most biting provisions are the notice and consent provisions of the Act. So what this basically directly means, what this basically means for businesses is that what this means is that there is a consent requirement. So all businesses will have to sort of take consent from the person. Consent meaning, and this consent has to be very sort of this consent has to be clear consent. It has to be affirmative consent, and the manner in which it is taken is usually written or it will be given by the government in the schedule or the rules that will be soon published. So consent has to be very affirmative. Now, while taking consent, there are two categories. There is one category for underage, that is children, and the other category is for protected persons. So, if consent is being taken from a minor, then there has to be a guardian, and all of those consent provisions will start getting activated. If the consent is taken from a protected person, that is any mentally handicapped or physically have any sort of protected person by the law, then the consent has to be taken from the guardian. But consent is very important in clear written terms. Another issue over here is the notice requirements that if the data that is what happens to the data after consent is taken. So will have to keep updating and giving notice to the data principal as to what if the data principal has a request, for example, to get the data removed, erased, or or if they simply want to update the data, all of that has to be done through notices, and there has to be a communication between the principal and the person who is managing the consent. In this respect, the consent also would require the DPDP make provisions for something known as the consent manager. So companies will have to dish out resources enough to handle and give it to a privacy team who will actually keep a manager over there and take consent, a consent manager really, who takes consent from the person who the data is being used. If the data fiduciary comes into the category of, let's say, a significant data fiduciary, now the government has the power to, to label or, identify any entity as a significant data fiduciary based on certain indicators. These are companies which are in heavy technology, satellite communication, or anything which is related sensitive to India's internal security or any other yardstick significant, they will be classified as significant data fiduciary. Now there is a whole lot of other binding provisions which I will delve into a little. For example, they will have to have more reasonable security practices. There will have to be a data auditor. So the data auditor will have to be an external person who checks whether all the consent provisions have been complied with, whether the DPDP provisions have been complied with, and the auditing has to be done by an external party. Other issues, for example, you will most likely need a data protection officer and a full privacy team if you are a significant data fiduciary. Moving on to some more provisions of the Act. What does processing for legitimate purposes is? All of that processing for legitimate purposes has to be within the confines of the law. And for example, some industries also have mandatory lawful interception. So, for example, if there is any issue of mandatory lawful interception, that will apply along with the DPDP for whatever the purposes, processing purposes, whatever it is. Because the DPDP Act only repeals certain provisions of the Information Technology Act. There is another Digital India bill coming, and then that will even change further mandatory lawful interception requirements and it will have a more wider impact. But this only repeals the sort of a certain provision on the IT Ministry rules, called the SDPI rules. When it comes to the data principle or the rights of the data principle. So now when you're taking data from an individual, the data principle has a certain amount of rights which can be legally enforced by the courts. And we will be talking about penalties later. These rights tend to be again, like I mentioned, right to get it erased, right to get it updated and all that. If these are not complied with, then there is a clear grievance redressal mechanism, and the individual whose data is being used has the right to, go to the authorities. First port of call would be, of course, to get to the company which retains the data and ask them to rectify it, or then it would be more towards other, sort of other, dispute resolution between the process. I will now start finishing it off by the more very important crucial aspect, which is the transfer and international transfer provisions. Now, when it comes to international transfer, unlike the DPDP, there is no adequacy requirement, like the European Union and America have adequacy requirements. None of that is in force over here. The law clearly gives the central government blacklisting powers to blacklist certain countries. So what would be very valuable for businesses to do over here is to identify the countries which are going to be blacklisted by the government of India, and then it would be the data should not be flowing to those blacklisted countries. So it's a very hard and fast rule at the moment. What is to be noted is if any other country has any other regime like the GDPR or anything, all of that will also be applicable. The Indian Data Privacy Act will also be applicable. And all the other provisions like the Foreign Exchange Management Act and any other provisions which bind international transfers will also be applicable to this, to the transaction for any international data flow. The good thing is the data localization requirements have been eased up and lifted, but then there are significant issues with international data transfers, and that I feel companies would have to dish out significant amount of resources to deal with that. If there are any significant data provisions and if there are international transfer provisions. What I will now do is I will now hand it over to my other two colleagues who will be talking about more on the dispute resolution and penalties. What the board. So the board can has powers to intercept. So it does not mean if the biggest risk that businesses face is that if the compliance is not up to the mark, the state, as in the board, because the board is an extension of the state can start stepping in and with surveillance powers, and you start checking if the entity has actually complied with the DPDP Act. So it's not a one-way thing that that only a company will be given the right to conduct its own audits. If there are violations and the government tracks that, then the state will start naturally stepping in to correct and amend those to their remedial procedures. And this will be taken by my colleague Mr. KPS Kohli, who I will now sort of handle.
Yeah, KPS, please go ahead. Tell us a little more about data protection disputes, the Personal Data Protection Board, the breach, how to define a breach. Well, these are all futuristic, nothing has happened, but you have to imagine and tell us a lot of things.
Thank you. Thank you, everyone. Thank you, Justice Sinha, for having us today. I think the bill is the act now is very important, and I think every business, everyone around in India will be affected by this act. So it has cast certain obligations on every business who collects data, personal data of anyone, of an individual. And it casts certain obligations on that entity to ensure that it is protected properly, it is kept properly, and also there is a mechanism which provides that whose data that we have collected, that data can be deleted, rectified, or updated. So all those provisions are by law mandated on anyone who is collecting digital personal data of anyone, of any individual. Now that's why it becomes very important because in today's economy, digital economy, nothing works many things works on digital, and that's how you process somebody's digital personal data. Now that processing is also defined under the Act. There are certain obligations that are cast on data principal, which is my colleagues have already discussed, and also on, and then there is somebody called data processor who will be processing the data. Now, all this is provided under the Act. How do you monitor all this? So, to monitor all this, the Act provides for constitution of a board called Data Protection Board. Now, that board will be set up by the rules that the government will come up with. Soon, the consultation, as per the last week, I think there was a statement by the minister that they are in the process of bringing out those rules. Now, the Act provides for there will be a chairman and number of members as the as the rules will define. Once the board comes in, so board actually serves a very important function in the entire ecosystem of data protection in India. Board could act like a regulator in some sense because it will be like a watchdog for everyone who is working within the framework of data protection. Now, I've already mentioned that there are data processors, there is data fiduciary, and then there are data principals whose data it is. Now, if data principal is the most important, I would say, most important woman in the entire universe of data protection, because it is that person should be kept happy as per the act. Now, if when the obligations are cast upon data fiduciary to ensure that he keeps that data well. Now, if he doesn't, if he doesn't do it, which is he doesn't update the data, or he probably there's a breach at his end. That's why a data protection board is constituted. It will monitor. So it will monitor whether the data fiduciary has done the due diligence that is required under the act. If they have not, then the data principal can file a complaint to the data protection board. So that's how it is works. So that's like a regulator. If a data principal is not happy with the data fiduciary or the consent manager, they can file a complaint with the data protection board. Under the act, as we have already discussed, that they've also provided that the data fiduciary should ensure that there are enough security measures, because today data can, it's there can be so many attacks on it, there can be so many breaches on it. If you don't have enough digital security measures like a firewall or a access restriction within your organization, or for that matter, an antivirus, then then people can actually can actually look at your data and steal it. Now, the Act casts an obligation to have certain standards in it, and if there is a breach on that, the board can look at it. So, board is actually that acts like a regulator. That if there is a breach, the Act also says that a data fiduciary, if they discover a breach in their system, they will inform the board immediately. The board will then pass an order, which could be, they can actually pass directions which are remedial or mitigating measures to ensure that if there is a breach in your system, how do you mitigate it? How do you ensure? Sorry.
Yeah, we've actually, we just go to restart in 5 minutes. We take a 5 minute break because our online, thing is going to restart in 5 minutes.
Okay.
So we'll just open the floor to informal discussion, and then we'll come back to what KPS is saying.
So you mentioned that data principal will file a complaint with the board as they are not happy. So the process like they have without a resource.
Anything. They said that you have to, as I said, that for a data fiduciary, you have to also update it. So if somebody wants to update, let's say I have my name is KPS, tomorrow I want to remove K from my name, I want to release it KPS. Then I want you to update, I write an email to you saying that please update my name to so and so. Then I receive an email from you, it still says KPS Kohli. Of course, I agree. I'll write back to you saying I have already informed you that you update my data, you've not done it. Now, if you've not done it, I can go to the board and complain. Tomorrow, I realize that there are certain, whenever a breach happens, now you can actually, online if you go, you can actually, there are certain non-for-profit websites which actually tell you where the breach has happened or whether your password has leaked. There's a leak in your password. You can actually monitor real time whether your password has leaked somewhere or it is available somewhere in the database. Now, if that has happened and I discover it, but the Act asks an obligation or data fiduciary to actually inform me if there's a data breach at their end. So if they have not informed me, but I got to know from somewhere else that their system was breached and my password has leaked, and they have not informed me, I can actually file a complaint against you to the court, saying that, of course, they've been lax on their security. Two, they are not even informed me after a breach happened. So, breach of their system, which led to stolen, my data being leaked. There are still such codes. No, they are not. But of course, they are there. It's like it's like Wikipedia for passwords in some sense.
You are data principal, it is your data. It is your personal information. If you are aggrieved, then whatever he has collected from you, that will be misused by some other person or by him. He is data fiduciary. He is in possession of your personal data. So you will complain. He will not complain. You will complain. Data principal will complain. It is for him. It is for the protection of his rights, privacy rights.
Even sports data would have not support. I mean, the online platform period. That's
So
we should mention about
there is also known as a
pages.
consent manager, who is appointed by the board, which you can approach as the first point of contact and say that this is what has happened. So it's user friendly as well, because it is not the board immediately. You can go to the consent manager and get your grievance redressed there. If that fails, then you go to the board.
For example, you mentioned that if there is a breach and fiduciary doesn't mention it, but principal finds it out. And
So that itself is a grievance that he found out and the fiduciary did nothing about.
I'll give you an example. If you go even now, if you look at, if you save your passwords on Google, I'll give you a simple example. Save your password on Google as test. And keep it very simple. If there is a breach happen, Google will tell you that if you save your password somewhere, go to your whatever the Google Vault is. It will tell you that some of your passwords have, and Google can save any number of passwords for any number of things. Whatever I open in Google Chrome, I can save my passwords there. So once you look at the list that is saved by you with Google, they will tell you that some of your passwords have been found in a data breach, which is available. So the information is available on everything is connected. So people know that when your breach happens and your passwords are leaked. Yes.
Please explain to me that who is data fiduciary,
Yeah.
and as I explained that he is data principal.
Correct.
So who is data fiduciary? Google is data fiduciary because
If he is collecting
data. So therefore,
so as I said, it revolves around data principle. The act revolves around data principle. So that's the most important person in the entire.
the data fiduciary where the data is required
It's stored.
Stored and is about to be misused. So that is the stage which he wants to know whether how I will able to know that my data has been misused. This is what perhaps.
So the data fiduciary is obligated to inform the board as soon as there is a breach. But assuming they don't, and the principal gets to know, then the principal has the remedy to go to the consent manager and say, so and so the fiduciary did not inform me that there was a breach. They were obligated to do it immediately. Not only they are obligated to inform, but they are also obligated to take immediate measures to mitigate that situation of a breach.
I'll give you an example. I'll give you a very good example. It's a practical example. I'll share it with you. So, Domino's India had a breach a few months back. No one knows because there's no act in India to actually tell you that. So, Domino's India had one of the biggest breaches ever. Now, Domino's India records all the, so everything is linked to my mobile phone, and it is linked through this mobile number. It is my name, what address I have ordered, and what pizzas I have ordered over the course that I've been ordering on Domino's. So my cousin sent me a snapshot. So his data got breached, and he sent me a snapshot saying that I now know that I have for lakhs of rupees over the years I've been ordering from Domino's. So see that's a breach that he got to know, but Domino's never told him. After the act becomes important. So the number was quite large. So I mean, he's a guy who loves food. So when I told him, the amount of pizza that you have ordered, you have actually opened yourself for thieves. They'll know he's a rich guy and he's ordering lakhs of pizza. So see, look at the implication of it. Somebody is out there that on this address, so many lakhs of pizzas he has bought over the years. Domino's should have told him if the act was early. They have not told him. But your data will also be there in that. If you have ever ordered from Domino's, your data will be there that how many amount of pizza, what pizzas and for how much cost have you ordered. There was no act. So that's a practical example. So he came to know that there's a breach in Domino's India and his data is out there.
Yeah, and in this case, Domino's is the data fiduciary, and they should not allow that data to go to anybody.
And if there's a breach that happens now in future, they will inform the board, they will inform the data principal that, and then you can take remedial measures. You can change your password to that one. First thing. Let's say you are on an e-commerce website, or there's a breach on an e-commerce website. I mean, there are certain e-commerce websites I don't use at all. Right? I may have ordered sometime, but my card information will be there. Somebody can receive.
Yeah.
And there is something I've ordered that I don't want people to know. But after the breach, they will know.
You should be told about
Right? So
They should be told.
they should be told, yeah.
Then you need to suggest that only on websites. Are we on?
Yeah, I think there is a very
We should start.
started, but now it's never to learn.
Yeah, those people we even left
The people that we learn.
wrong in this data.
We need to suggest that websites are the data fiduciary.
Yes.
Websites.
Yes. Most of them. There's even retail. When you go to retail shop, even for Domino's India, if I order it at the shop,
Anybody other than the websites can also be.
yes.
All bodies who
Anyone.
are processing anybody's
Data.
individual
collecting data
They
and
want
digitalizing it.
It is not only website.
Even
Anybody
a-
who's,
this is what I-
yeah, anybody who's.
A courier service guy.
Even a shopper stop or lifestyle
I mean,
or
Yeah.
Or
Even
say,
for
So-
a shop where I go to buy my trouser
Correct.
and I
Is the data
They
fiduciary?
take your number.
Yeah.
they get my number,
Yes.
they get my email,
Yeah.
and then very regularly I receive something from them.
Correct.
So we'll
Yes,
now.
He's the data fiduciary.
Every month, sir. So in fact, even a local shop
Yes.
where I have a contract with him to send me water, drinking water. He's a data fiduciary. If he has my data, if he knows that how much water I collect, my phone number, I identify the data of me.
Yes.
Then he's a data.
the schools, the hospitals, wherever
Everywhere.
it's connected.
Yeah,
Schools,
but
hospitals.
the exception
This
is,
is the implication.
the exception is that any data which is in the public domain is exempt.
So, it's very
Is exempt.
We are now.
Any data which is in the public domain is exempt.
Online or offline?
Obviously, because if you can find it anywhere on the net, then how can you hold the fiduciary liable to manage that?
We will now actually
Yeah.
revert back to. We will now revert back
Maybe,
to Mr. KPS Kohli.
And if I talk,
We can discuss it
KPS
at the end of
Kohli will be
the session.
discussing on the data protection board, its penalties, and we'll.
So, so data protection board, as I said, is probably the regulator. So we went offline. Sorry, apologies for that. But we were just discussing that what is the role. So the data protection board will regulate the sector. We have already discussed about the consent manager. Now every consent manager has to be registered with the board. So board would be like the regulator for them. So you can't act as a consent manager till the time you are registered with the board. And if there is any qualification maybe into the rules, they'll come out with. So we don't know how it will all shape up. But there are broad pointers as to how the act will work. So we are aware of that. So I was on the powers of the board to regulate. One, I've already mentioned that they will register. They'll be the registering authority for the consent managers. If there is a breach that happens, then the data fiduciary is obligated to inform the board. Board can then do corrective measures, suggest them corrective mitigating measures. Three, board can then also investigate whether they have taken the correct measures, whether they have followed the mandate of the law, which, because there are obligations on data fiduciary is also under the act. So if they have, whether they have followed that or not, if not, then there are penalties. Now, but there are three more unique features of the board. First one is probably more, I mean, it's just anecdotal. That I think that's probably one of the first, or the first board or first regulator where they have said it should have a digital office. So digital office is also defined under the act. So digital office is that you intend to do everything online. So, I mean, as much as you can do online. So, which means that board will act as an online office anywhere, the person sitting anywhere can just write an email, whatever the procedure would be. We don't know whether there'll be a portal, whether there'll be an email. We don't know. So, but it would be acted online, and everything redressal can be done online. Two, on the as board also, as we have already said, that board can investigate whether they have been following the mandate of the law. can provide mitigating measures, suggest mitigating measures or direct mitigating measures to the data beneficiary. The board also has the power to actually push the party, the act mandates it that if there is a requirement, if they foresee, they can actually ask parties to go to mediation. So the mediation is also provided for under the act, one of the methods by which board can resolve disputes. And lastly, there is a very interesting provision under the act which is called an undertaking. So the board has the power by the act to actually take an undertaking from the party and close the matter there. Now the undertaking, the terms of undertaking can be suggested by the party. So it's like plea bargain in US, where if you have made a mistake, so you can actually admit and say going forward I'll do X, Y, Z, and then it is accepted and the matter is closed there. So it's sort of like that. So board can take the undertaking from the person who wants to close the proceeding against them. The undertaking can, I mean, they can actually, it's obviously subjective, whenever, what measures that they will take, is whether they'll pay any penalty, whether they will, compensate the people whose data has been breached. We don't know. So it's only when the rules will come out will come to know. But that is there where board can actually close the proceeding by taking an undertaking. If the undertaking is breached, board also has the power then to impose penalties. And all this, of course, without following the principle of natural justice. Wherever board passes, whatever order board passes, it has to hear all the parties. So if data principal makes a complaint against the fiduciary or a consent manager, the board will ask for their side of the story and then pass the appropriate direction or order. So I mean that's the broader perspective. And as I said, board is a regulator, and it will be interesting to see how the entire ecosystem will work. We were just discussing that how impactful this act is now. I mean, everyone, even where we are sitting today, they have become data beneficiaries because they have your data and they, they have Girija's data, her phone number. So they have become data beneficiaries. We are a data beneficiary. So the breach happens. So they are obligated to inform. So yeah, that's my.
So they all are the fiduciaries.
If they know that we are only collecting data. Yeah. We are collecting data for data.
So I'll now request Girija to please give her comments on this topic.
So I'm grateful to Justice Sinha for joining us and Mr. Sukanta Dey for moderating this panel for us. I think it's not easy to manage lawyers, but you manage this job pretty well. And I also thank all my co-panelists. So I'm grateful to Justice. I know you've come away from a distance from wherever you are to attend this session. I'm just going to do a quick wrap up of the Act, and then I'm going to speak about the penalty provisions and also some of the examples under the GDPR and how we can contrast them with what we are heading into in the future. A quick wrap up, I would say that I think it's a very landmark legislation because it really empowers individuals and the common man completely to have control over their personal data. I think this is the first time that we see this here. When I say it empowers us, I mean we have the law has given several rights to individuals. That is the principle, the data principles. How they can access the data, how they can modify it, how they can use it, how they can specify the user to the fiduciary. They can completely give direction as to how far that data can be used and for what exactly can be used. Consent is absolutely essential under the Act, and the fiduciary is obligated to give notice about the consent, give notice before taking the consent, and in the notice also there are very strict provisions because they are supposed to be informing the individual as to what their data is required for and the time period and for what and to what extent that data will be used. Also, in case there's a breach, what the individual can do and who they can approach to for in regards to that breach. So I think it empowers the individuals. They can also nominate people to handle their data. They can access it anytime in the future. And I think There are also duties cast upon the principals. There are two important duties. Firstly, that they are obligated to make sure that they don't impersonate anybody. And secondly, they do not file any frivolous complaints, because that can be, a burden on the whole machinery unnecessarily that is done. And there are penalty provisions for doing any of this. The second part of this is that I think the buck stops with the data fiduciary. They are absolutely obligated to make sure that there are enough safeguards and measures in handling the data, and how that is, if the principal wants to erase the data, they have to ensure it is done. If the principal wants to withdraw the data, they have to ensure it is done. If the principal wants to modify, they have to ensure that that is done. So there's a huge obligation on the fiduciary. In case any of that doesn't happen, the breach, it could be considered as a breach, and there are very heavy penalties for it. So I will go down and explain the penalties now. It is also a very user-friendly act, because firstly, there's a consent manager which you can approach. Secondly, this act bans courts completely, approach to the court. So nobody can go and take a stay order from the High Court or the any other court or the lower courts, because the courts are exempted from this process. They have to go to the data protection board only. And there is also a timeline. I mean, a lot will come in only after the rules come in, but there are certain strict timelines which people should be aware about. As soon as there's a breach, you have to inform them. As soon as whether the fiduciary or the individual gets to know about a breach, you should be able to take mitigation measures immediately. Under the GDPR, you have to inform a breach within 72 hours. So, I hope our rules are also on the same lines, because that will give more teeth to the act, actually. And also that the board is under an obligation to decide a breach within 6 months. The appeal period from the board's order is within 60 days. So these are the only timelines that we have as of now. There will be many more, because we need the consent within a time period. Broadly speaking, there would be, I think, 30 days given for most activities under the Act, but it's not there as yet. We have to wait for the rules. Now I'll go on to what are the breaches really that can happen under the Act. One is the failure to enforce safeguards or security measures while handling the data. Second is failure to report a breach to the board or the data principal in a timely manner. Third is failure to address the breach or so that you mitigate the breach in a timely and an effective manner. So these are all the broad areas where there will be breach. Of course, there will be breach beyond this also. If there is a loss of data or destruction of data, that all comes under the safeguards and measures that are required to be done. I think KPS had explained all the steps that you can go to before you approach the board, so I'm not going to go over that. And he's also explained the powers of the board. All that I'm going to now go on to is the penalties that are available under the Act and what is available under the GDPR Act. I'll just do a quick comparison. Under the DPGP Act of India, we have 250 crores of penalties. So the penalties actually range from 50 crores to 500 crores, broadly. It's 250 crores when there's a failure to implement reasonable safeguards or security measures. It's 200 crores when you fail to notify personal data breach either to the board or to the data principal. It's 200 crores if there's a breach of additional obligations that are pertaining to children's personal data. It's 150 crores when your failure to observe significant data fiduciary. There's a significant breach regarding the data managed by the fiduciary under the fiduciary's duties. And it's 10,000 rupees if there's a failure to adhere to the duties. And it's 50 crores when there's a miscellaneous violation under the Act. And it's if an individual violates the act, it could go up to maximum. It could go up to 500 crores. So yeah, anybody violating the act, whether an individual or a fiduciary or a consent manager or a principal, it could go up to 500.
No principal can't violate.
Even a principal could, if he's not following the duties, if he's impersonating somebody or he's doing something which is, he's
That is impersonation. For that, I will be penalized under the IPC.
no, even under the act, if there's a
It is for
violation
my
of the act.
protection. It is for my protection.
But if I'm violating the act also, the act has penalties for me.
For example, sir, Pakistani agents are regularly impersonating as women and trying to engage on social media and gain your information. But that person is guilty of impersonation with a wide intent. They will be taken down for that under this.
So there he is becoming a data fiduciary because he's trying to extract data. Anybody, the definition of fiduciary is the guy incoming of the data. The definition of the principle is the outgoing of the data. It's got nothing to do with individual or large companies.
No,
if
but
I'm collecting data, suppose I'm collecting all your data, I automatically become fiduciary because I'm collecting your personal data alone.
no, but as an
Then I'm storing
individual,
data.
no, even as an individual, my personal data, suppose I am doing a violation under the act, as far as my personal data goes,
Yeah.
that would be also penalized.
Yeah, if you're giving wrong data,
Yeah.
yes, of course.
Impersonation or
But if I'm collecting other people's data, then I'm the fiduciary.
yes, that's right.
Impersonating, I think the one more example. Somebody is impersonating me on Twitter.
Yeah.
And taking out, terms
Asking for money.
against the
So
government.
not equal to it.
Inciting riots. I'm
So,
a known person.
that will be-
I am being seen to give a statement which is, communal in nature, and I cause a riot. Well, and I am asked for a say, I didn't give this tweet. Somebody else gave that.
So you are giving wrong data.
The other person.
Impersonation.
Yes.
He is impersonating me.
So he will be charged for impersonation.
No, even under the
Does this
act,
act,
anything dealing with personal information.
does this act,
Also, we need to
Actually,
Will
the
be
line
charged.
is very blurred.
There's a duty also cast for the
So
principal.
literally, in the case of impersonation, he will be charged by this act as well as the other act.
Yes.
Both the acts,
You
because I'm
could
giving wrong data.
Yes.
I'm giving, let's say, wrong date of birth. So something like that.
That has a criminal angle also, that would be.
Yeah.
Or I'm misleading somebody.
I'm misleading
Yeah,
something.
you could be
Correct.
misleading somebody. So any violation of the act, that's why there's a wide range. There is also miscellaneous provisions of penalties, which could include many things beyond.
It's not on banter, but on truth. If you go to the websites where men and women seek partners, their date of birth is always wrong. I'm say 50 years old, I say no, I am 45 years old. So that is violation of data by the way. I'm just giving you on banter, but also that is violation of
So,
data.
but I think that would be protected under confidentiality in any case because.
But I'm giving wrong data. So but it happens all the time. So I'm saying, so these are the realities of life. So that is why this act is there so that we adhere to the act.
To this extent, right? You say that if I offer wrong data, wrong information,
Yes.
then in that case I am liable.
Yes.
Or also if I file a frivolous complaint against a fiduciary, then again I'm penalized.
The frivolous complaint is another.
Is there a time frame for the complaint to be sorted by the board?
Yeah, 6 months by the board.
6 months. Right?
Yeah, 6 months by the board, but we don't know still, like how much time the data should be given, shared, if there's a erasure required, how much time period is, that will all come in the notes.
So Girija, you continue because we don't have so much time.
So as far as the GDPR goes, I want to talk about the penalties under GDPR. So they have different levels of penalties, and those penalties are linked to the annual turnover of companies. So that's the broad difference between the penalties in India and the penalties under the GDPR. The level of penalty has to be assessed according to the extent of the crime or the breach under the GDPR. It's 20 million euros, or in case of an entity, 4% of their global turnover of the preceding fiscal year, whichever is higher. And in case of a lower breach, it's 10 million euros, or Uh, in case of an undertaking entity, it's up to 22% of its entire global turnover of the preceding fiscal year, whichever is higher. So, and an undertaking has been defined as any entity that is engaged in economic activity, regardless of their legal status. So, that's the difference in the penalties. Now, I'll give you a few examples where, under the GDPR Act, where there were penalties imposed for violations under the GDPR. One of the cases was against Facebook, where a fine of 1.2 billion euros was imposed. The fine was issued for transfer of personal data of European users to the US without adequate protection measures. Similarly, other giants, tech giants like Instagram and WhatsApp were also fined for mishandling personal data of users, especially when they were transferring data outside of um, European data outside to other countries. Another one of the huge fines was imposed on Amazon. They were imposed a fine of 746 million euros. It was an investigation was conducted on how Amazon was processing personal data of its customers, and it was found that there were infringements which related to Amazon's advertising targeting system that was being used without proper consent of the customer. Another example was when Facebook changed their terms of service for its users right before the GDPR was enforced. They changed the legal basis from consent to contract for its processing activity. So earlier it was just, they would take consent, now they had a contract. But what Facebook did was that it asked its users to accept the updated terms of service to access, or they would not get access to their Facebook or Instagram. This was found to be forced consent, and 265 million euros was fined on Facebook for doing this. So very strict penalties for doing any breaches. So broadly, that's what I had to say.
Yeah, I think what is very interesting also, which will impact businesses a lot, is that just now, a little while ago, the Competition Act, the Mergers and Acquisitions and Competition Act was also upgraded for, so there are, which is linked to turnovers and violations of that. So, so there's been a change in the whole ecosystem. First, the Competition Act has been changed. Now, this is the data protection, a certain provision. The SDPI rules are being replaced by the data protection, the DPDP Act. What is coming now is the Digital India Bill, which will overturn the whole Information Technology Act of 2000. And then, there is going to be a lot of other, various other smaller bits and pieces of legislation, which will actually overturn the whole framework, whether it's 5G. But the Digital India Act will, 5G, satellite communication, mandatory, and all other, various other things. So I think, giving on a whole, really, it's not just really looking out for the data protection angle. That is only one small aspect. When the Information Technology Act is going to be changed, when the Competition Amendment Bill Act has also come out, and now there's a Digital India Bill which is round the corner. So that is a bit unlikely before the 24 general election, because it's a very vast piece of legislation which will substantially change the entire framework, whether it's satellite communication, whether it's phones, but that will change the whole framework. So I just want to get in a viewpoint from any of our other panelists over here, especially Mr. Dey, who is a management consultant, and who the person who would be more in the tech sector because he's had experience in the IT sector before. As to what the precise impact on businesses is, how can they gear up, given that the whole ecosystem is changing, not just the data protection, because just the small thing.
Yeah, so I think so far what has happened is the data, as Girija rightly pointed out, the data fiduciary is the big giant. Who is the data fiduciary? The big ones are like the Amazons and the Googles and the, in India, Flipkarts and all that. They are the big giants. What do? They take the data of individual customers, B2B, B2C, whatever, and they do business. So a huge amount of responsibility comes on the data fiduciary of how to collect the data and keep the data protected. Now that requires a lot of technology. For example, you require a lot of cybersecurity, etc. You require protective walls. It is not enough. Let's say I am an honest data fiduciary. but for some reason my technology walls are broken. For some reason. I can't say, I'm sorry, I didn't want to leak the data, but this wall has gone, this encryption has gone, and now so many 100 million users' data is out in the market, but the responsibility is mine. So I have to use the appropriate technological walls, which is money. I have to use high-end technology experts, and I have to make sure that all the data which I have collected, of millions and millions of users, are fully protected, whatever the data are. Now, the word fiduciary comes from the banking system. So, how are banks? Why do you put money in one bank and not in the other bank? Because of the fiduciary history of the bank. For the last 300 years, the bank has never preached anything. You put the money, and if you wanted the money back, and the next second you got your money back. That's how the legacy of the bank has been built up. The fiduciary sort of character of that organization has been built up. Similarly, these type of fiduciary large bodies of the Amazons of the world, etc., will have to build up that type of a reputation so that you say, hey, I don't mind giving my data to say HDFC Bank or to Amazon or to this because they are, of course, they're very honest, but they have got huge technological sort of space and technological capability to keep my data completely protected. It is also a well-known fact, I come from a marketing background, it is a well-known fact that when you go to, like the example of the dating sites I was giving, it's a well-known fact that when you buy products like his cousin who bought tons and tons of pizza, then it is marketing companies get a little this thing that hey, the guy is buying pizza, so let me send him some ads on pizza. But actually, how does he know? How does Amazon know you're buying pizza? Because he has looked at your database. He has peeked into your database, which you're not supposed to do. Like the bank relationship managers will peep into your account, say, hey, this guy got so much money. They'll bring you, hey, there's a new mutual fund. Would you buy it? Now that again is wrong. That is against, you're not supposed to, that's a private data that you've got a large sum of money sitting in savings bank and this relationship manager has peeked into it and he'll give you a ring. And this happens. I'm talking about the reality on the ground. This happens all the time. Just as much as in the what is called Bumble or whatever the dating site is, where you see age is 35, 40, 25 and all that, when you actually meet the guy who get a shock. Hey, I said it's 35, it doesn't look 35, it look like 55, whatever, So I'm just giving in a humorous way, but the reality on the ground is different. Because I'm trying to show the importance of data. That by fiddling with a little bit of data, you're trying to get an advantage of either yourself or the fiduciary yourself. See, the large fiduciaries will always, because they are kind of a little distant away from the actual business, so they will always, the top people on the board will always ensure that the fiduciary walls are absolutely intact and our data is well protected and they have their reputation, which is far more than trying to do something with some 100 million users data and all that. But having said that, Girija gives some very excellent examples of very large companies like WhatsApp and Facebook and Amazon who actually got caught. And maybe they got caught not because of intent. They were transferring the data for some research. Sometimes large companies do that. But then you have to do that in a very, very clinical environment and make sure it doesn't go out. It just remains within your internal system for the research. So these are important vistas which will open up. And as Neil rightly pointed out, with the Digital Act coming into the picture, the whole framework will change. But the good thing is that I think this legislation took them 6 years to make, but it is a very well thought out legislation, and the legislation is there to drive the business. They kept the courts purposely out of it, and this is probably the only act which doesn't have any criminal liability. I mean, you won't go to prison for even 1 hour. That is not the intent. This is the thing. It is not. That is not the intent. The criminality is not the intent. The intent is, hey, you have used the data to make money, so you will be penalized with money. So that is the principle of the act.
Because the IT Act actually has criminal provisions.
Yes.
Which cover, which also protect data.
Can fiduciary pass on the liability to the processor?
Yes.
Yeah, they can, but there's an agreement that is
Yes,
based
not.
Yeah, but they have an agreement. So it will be as per the agreement that is signed with the processor.
But you need to have a clear law.
This is a very important
It's
thing.
open to contractual interpretation. It's a question of contractual interpretation.
Processor will do it for the fiduciary only.
Yeah, so I'll give you an example.
Related was mentioned that the fiduciary
You
pass
can't say that it goes to the possessor.
No, it
can't say
depends.
that.
Yeah, no,
If it's mentioned in the agreement, if it's
Yeah,
if
if it is
it's
in the
there, it can pass on 100% liability and
They're
beyond
all
that.
indemnity by the.
I'll give you an example. So there is a,
Indemnity, full indemnity,
there-
that
there is
the
a-
GDP liability falls on the financial, not on the
It's
But the very
in
principle-
relation with
Yeah,
the
even in the agreement it is mentioned
It
that
just,
the liability
It could be back to back, right?
When you go back to back,
however, in sharp contrast to this, the EU does not allow this. The European Union
I
GDPR
also not
does not
allow
allow,
it.
which is interesting.
Processor is under the fiduciary.
Yeah, well, it's not that
He's an agent, only responsible.
Yeah,
He
to
should
an
also be
extent,
responsible.
but the GDPR is more clear also.
Responsible,
GDPR
right?
is more clear that you can pass on, you cannot pass on liability.
You cannot pass on.
The GDPR, our bill leaves a lot of room for contractual interpretation, which can become a big risk area for companies, and the government must clarify this. Because the GDPR is very cuts and dry. You cannot do that. They have an accounting principle and all that enforced and various other things. I don't think we have time to discuss that. But the Indian version actually states that if there is a contract, as Girija rightfully, it clearly states the liability can be passed on if processing is outsourced. Now, in some cases, there is even provision where there are exemptions of the DPDP, for example, even outsourcing. In situation of outsourcing, it is given clear-cut exemption. So there are the problem over here is with the risk areas over here is that it's given a lot of room for these to be interpreted by the courts and by the judicial authorities. So, for example, if I am in a data fiduciary and I pass on the 100% liability to my processor, even though he's an agent, then that gives the processor the right to actually take it to the court. That is judicial interpretation. That is judicial interpretation.
You can recover a part of the claim from the processor.
yeah, and also one of the other salient features which I have been forgot to mention is that it has extraterritorial jurisdiction. So any foreign entity, yes, so any foreign entity dealing with goods and services in India and handling personal data of residents of India, they will be falling under this act. Residents. So we will in American.
Make you speak before the meeting ends. If you don't speak, you make him speak before
Yeah,
the meeting ends.
Yeah, so we have now exactly 10 minutes left, I think, because we'll be breaking for tea and coffee over here. Now, if anybody has any questions, I mean,
please go
if
ahead.
you have any questions for us, you can ask them and we'll be happy to, you can send an email, we'll be sending you a lot of material and video recording this, but if you have any questions, if you want to put across to any of our team members, please do so, or by email or just now.
In fact, Ron, we'd like to hear you. At least say hello to us.
Thank you so much for having me and very interesting discussion. There's a lot of uncertainty regarding the Indian market and data privacy, while other countries set up policies quite clearly and really did an amazing job in guidelines to the proper way organizations should treat their customers' data. And it feels like in India there's a lot of obscurity about this. For my company, which by the way, just in a few words, what we're doing is setting up IoT devices in India, like for example, is the soil moisture sensor that's being put in a field that measures soil moisture for precision agriculture using satellite communication. And so for our company, there are new challenges in the field of both profit perception and it's very unclear if we are part of other countries and data privacy, which is just now being legislated. This was a very interesting discussion for me, and I really like to know if you're having a later discussion regarding profit perception as well.
Hey, Ron, thank you very much. So I think anybody wants to give any comment, Girija, anybody on lawful interference, I think he wants to know a little bit about lawful. No, he's saying, we'll just start directly, of course, lawful interception is
I think
there.
KPS has
Just to answer your question, Ron, I think if I understand, it's only an IoT device. So this bill probably doesn't affect that business yet. Because India is not earlier, there was in the earlier iterations, there was a discussion of having a community data also included in the digital protection bill. But now they have taken it out. So presently it is only the personal data that is required and not the community data. Had you been only an IT, had it been a community data also, probably you taking away your IoT device measuring the soil moisture and everything that would fall under that category and that would have been regulated. So now it is not regulated. Two on surveillance. I'm not sure what is your question on surveillance because use of satellite licensing everything is quite clear now.
What I think the angle is that the Telegraph Act and the IT Act of 2000 is what governs the surveillance and privacy laws. So when it comes to mandatory lawful interception on satellite communication technologies, that will of course it is directly linked to the Information Technology Act and this DPDP is a build up to that. So when I think it's more a case of where we will have to wait a little while longer to see the direct impact of the Digital India Bill. This DPDP gives us only a flavor that that the Digital India Act is going to come out, which will directly affect law mandatory lawful interception. But as a parting comment, seems to be very highly likely that the state will be given further powers or the government will be given further, given the reading of the DPDP, the way they handle international transfers, the state will be given a lot of powers to deal, further broadening their powers to deal with mandatory lawful interceptions. Because the Telegraph Act and the IT Act are pretty dated, right? So anything to do with any state surveillance or surveillance or privacy that will come directly under the remit of the government because the current DPDP Act also has done the same despite everybody talking about that the DPDP is quite different, it does have certain things which a lot of foreign players have commented on the surveillance laws. So it is likely that there will be surveillance, there will be the surveillance will be in place, but it will be empowering of the state and its various machinery. Now that is something that there are, I think the government of India is open to, they take a lot of stakeholder submissions from foreign players when they're drafting because, it's more like a balance of national security and lawful privacy and surveillance and all that. So those are questions which, will probably come out in the next couple of dialogues once we see how the DPDP rules are being framed, once we see how the penalties are being handled down, and then what the surveillance elements of the DPDP is given that the state governments are excluded from the DPDP to a large extent. For example, if it's in the course of, for example, court proceedings, if the information is being taken for an investigation, then the DPDP is not in the broad exemption for the government and the state authorities, no police investigations. So mandatory lawful interception would come into that framework where the government is doing something for the state. So it would be exempt, the government would be exempt from foreign DPDPs, which could be a risk area for businesses. But all of that nature and method and type we will only know in the forthcoming discussions as to how the DPDP has been applied and the extent to which the government intends to affect mandatory lawful interception, surveillance laws, and the Telegraph Act, the ITP will be. I hope that gives you a certain answer. We wrap up with that.
Yeah. And Ron, it will also get finally put in that digital bill which is coming out.
Yes.
So that will all get integrated into that system. So I think if anybody has any last comments, etc., please go ahead.
Just to clarify, this bill does not apply to the critical information infrastructure.
Anything to do with the state. Anything to do with the state is if you, for example, if there's any investigation on, if the court proceeding on those issues.
I think you're coming from the IT Act because IT Act was covering critical sensitive information only. This act is much broader. So it covers critical sensitive personal data as well as personal data in general.
Like you mentioned about IoT devices, which is used especially critical information infrastructure.
Yes. So it covers that, but the question is whether that is legally done or illegally done or what is it being used.
No, whatever information has been converted into digital information.
And it is dealing with the personal data. It has to be personal data.
where the data identifies the individual.
It's
If
more
it is
into
not-
personal data.
Yeah.
This is the more agricultural, it's more.
If it is some other kind of data, that is not covered under this act.
So I think that's.
No, you
Actually,
can
we
do personal
only
data.
have 1 minute left. So
Whether it's
if you
critical
want,
and
if you want,
sensitive,
then
that
we're
doesn't
going to
matter.
now, I can go for the tea and snacks are there. If you have any questions, please feel free to, write to all of me or us,
Any other
anybody.
questions?
I will be sending you advisory notes in any case, and we'll be sending you a video of this,
There are few questions.
Yeah. Construction, you just have a.
Thank you so much for joining us, Ron.
Thanks so much. Thank you so much, Ron. Thanks a lot.
Something before we-
In fact, you're gonna move it, but we can have an informal discussion.
I'd like to make some comments on what is spoken so far.
Yes, please. Yes, please.
Very happy to be in this August and digital working. I've been doing some research in information warfare. And so therefore cybersecurity also impacts, and we've been following this whole evolution for some time. So in fact, as you said, this particular business evolution which occurred 2019, the first video enabled a draft bill, which was that time called the draft personal data protection bill.
Yeah.
It ran, and this government, as you were saying, that has been very consultative in nature. Put it out in the open domain. There were several objections. There were 88 amendments, asked for it. And one of the reasons why it got withdrawn, the bill was withdrawn. It was withdrawn because one of the comments from the legal community was it needs a much wider legal framework. That's not what we're seeing happen. Then came Digital Data Protection Bill 2022.
And technological.
The second one.
Because
And
data which is not digital is not covered under that.
Yeah.
So otherwise, the 2019 would cover any and every data. Yeah, so it will be much wider, right?
so in the second one, it was called Digital Data Protection Bill. And there were a lot of things. One of them you mentioned. In the earlier one, it was still data localization. In the second one, it was whitelisting of cross-border. Now, as you mentioned, this time it is blacklisting. I don't know which one is better or worse, but it is more open. So now
Geopolitical threats, no?
in the first one,
The
it
blacklist
was
is typically smaller than the white list, generally.
So because I can understand that thumb rule is under the act that we will share data.
so it is
Okay.
changing.
Yes,
It's an evolution.
the thumb rule is that, but there are exceptions to that by saying it's not permitted to this country.
So earlier the point was nothing cross-border. Then they said, okay, we will whitelist certain countries and we will permit only there. Now we say, no, it can be anywhere. We will blacklist it.
No, but because that is also for another reason.
I'm just talking about evolution and this.
It's also for another reason because there are companies from overseas coming into India and handling our personal data. If we want that protection, then you have to get something in return.
Exactly.
So that's the issue there.
I'm just saying the way the government has taken its
If you have
stance.
to curb Amazon, then you have to do something.
But the way the government has taken its stance, from completely closed to only whitelisting.
Yeah.
And now
It is
anywhere except blacklist.
Yeah, you're
That's
right.
about the way it has changed. Then the penalties part, it was 5 crore in the 19 one, it came to 250 crore in the second one, and now again broadly 250, and fine 500 anyway.
It is.
It's only 250.
250
But
It's a schedule, the schedule.
I actually
Up to 5.
it varies from 10,000.
It's from 10,000 to 250 crores.
Yes,
250
That's the rate.
Maybe
Up to 500.
500.
250, yeah.
250 is the cap, which I should
That is the act in the schedule. It's up to for certain
Oh,
situations. So
Anyway, it's a big change from 5 to 250 itself for the weekend. The question being raised is that for smaller companies, it's very difficult to.
They won't be able to survive on these.
So
Yeah.
what should be done? That it should be linked like the GDPR, it should be linked turnover of the
Turnover.
company, which presently is not there.
But there is some something about smaller companies.
When you look at the text of it says that they will examine all these
Yeah,
things. So I'm sure it will evolve in a little better manner. Criminal liability rule.
Yeah.
Yes. What you mentioned. In the 19 one, it was still there.
Yes.
Prior to that, of course, it was different. In the 22 one, it was removed. And again, now it is still not there.
But I think if you look at it, how it is structured, there are two sets of bifurcations that we have done. One is anyone who is a data fiduciary, and then there is significant data fiduciaries. Significant data fiduciaries have higher responsibilities.
I'm just
We already know the history government has with the
exactly. One of the reasons why some of them resigned was that.
No, exactly. So they wanted a Indian person to headache India, and no one takes that position. But significant data fiduciary is mandatory. Have to have an Indian guy, somebody who is available there in India. So there will be two categories even under the Act. So that is taken care of.
But there's a reason why criminal liability isn't there. Because a lot of people will refuse to do business in India and get criminal liability. You've seen the cases in the past.
Yeah, because that was
but it's a detriment for people to do business there.
Exactly. So the government is listening to that what we say. Then there is still a lot of unguided power for state.
Broad exemption.
So then board is all powerful.
Yeah, but generally the government is exempted from DPP.
I'm talking about exemption of CID, ID, police.
Yeah,
There's a lot of exemption which was criticized in the 91, in the 22 and now it's still there in some form of implementing that work.
I think it's a welcome move, isn't it? What do you think?
The criticism is that government agencies will use the data, pass it to the political party for political manipulation.
Yes.
That's the problem.